Okay, shall I start now?
Yeah.
Okay, good morning again to everyone. So, as you very well know, confidentiality and data protection is a very essential part for our profession that day to day we are seeing patients, and particularly we have to be very careful regarding managing confidentiality and personal, patient information when we are particularly working in emergency department, that we're a very busy department. Now, before I start this topic, I would like to ask a few couple of questions to know actually what's your understanding about. So can anybody define what confidentiality is? Anyone? Okay, so for confidentiality at the national level, GMC has guidance, NHS has a code of conduct. So what are the principles? Does anybody know on GMC? What are the 8 principles? Okay, fine. Anybody has been aware that we have a trust, local trust, confidentially code of conduct? Is anyone aware about that? Just say yes or no. If anybody knows that, say, okay, yes, I know. Anyone? Fine, last question. Anybody aware who is our data protection officer? Who is our Caldecott guardian in our trust, Doncaster?
Yes, it's a medical director, and the data protection officer, I don't know the name. We have a.
Yeah, so data protection officer Ken Roywood, and what you rightly said, Mr. J, Caldecott Guardian is our medical director, Team Noble. Very good. So looking at the questions I asked and the silence, I think it is definitely important and it's beneficial for this topic to be discussed. Oh, it's not going. Okay. So the objectives I've kept it very simple because it's a huge information. If you ask me, information governance, data protection, confidentiality itself, like in GMC, it has 138 paragraphs, and you can go like hundreds of pages of about it. Lots of data protection, online courses. If you go through, they have a lot of things to learn. But I have just focused on our own practice. What basically we are focusing is what exactly confidentiality is, what are the important principles that we need to know of, what is the local policy that we need to follow, not on the national, our own local policy, and what the basic information governance our trust is advising us, and overall what's the Caldecott principles that we need to be aware of. So to start with, like I said, what is confidentiality? So as you can see, confidentiality in our setting, particularly health and social care setting, if we see, is the practitioner that should keep a confidence between themselves and the patient as part of good care practice, which means that usually, this is under a common law, that it is expected that the health practitioner shouldn't disclose the information which is provided by the patient to anybody else unless and until it is needed in some exceptional circumstances. So if you think under common law, confidentiality is a legal duty as well as an ethical duty, can anybody tell me, is it an absolute duty?
No, it is in certain circumstances, you are required to divulge information.
Correct.
I think it's not an absolute, is it? Because if the court of law tells you are certain crimes, where there's a necessity of protecting the public.
Absolutely.
And there's a protection of the
That
life
is the
of the patient.
reason. That is the reason confidentiality as per NHS code of practice, it is considered as of utmost priority and a first-class confidential service, basing on mainly 4 points. We need to understand what's the reason for possessing a personal information of a patient. We have to understand why a consent for particular disclosure is needed, like what we say as an implicit consent or explicit consent, and where exactly you need to use this information for whatever reason it may be. You have to be very careful when you are dealing, particularly in NHS organization. And when you're dealing this sensitive information, you need to have the patient under the trust of the patient should be utmost of value for for our healthcare setup, so that they can confide in us their sensitive information. And also you need to make them understand that they have a right to access for this particular their own information, their own health records, This is what is emphasized on the code of practice under the confidentiality heading in NHS. Now, GMC has definitely given a very nice guidance on it. So I've taken out few important points. Like with Mr. J said, confidentiality is an important legal and ethical duty, but it is not absolute, because you may be required by law in certain cases, which we will discuss about it, that you can disclose as abided by the law, that it is a statutory process, or there is a explicit consent given by the patient, where safeguarding issues, patient care is prioritized as to confidentiality matter of the patient, where this confidentiality law, common law, doesn't apply, rather the statutory law applies. Now, this guidance, why did it come up? This came up and was updated in 2018 in requirement for the General Data Protection Regulation as per UK Data Protection Act 2018, which almost is the updated of the General Data Protection Regulation. It follows basically 8 principles that we need to know in our day-to-day practice. What are these 8 principles? Use minimum necessary information where needed, where you can anonymize a patient information. Like, I'll give you an example. You are reporting a communicable disease or a disease which needs to be reported to the public health. You don't have to give all the patient details. You can report that a case of, say, measles outbreak has been there. So certain cases where you can avoid, certain cases like research studies, you don't need to have all the patient identification. You can anonymize the patient for a research study. Manage and protect information. This is very important. When you are dealing with sensitive information, and particularly with patient health, and they're all relevant for identification, you need to know how you can protect. So our local policy has a very robust kind of policy, where we'll further discuss in the session, that how you can manage and protect all this relevant information. And always at your level, when you are a doctor practicing, why I'm focusing is because my audience to you guys, you all are doctors, practicing doctors. You need to know your responsibility, that it is a mandatory requirement that you need to be aware about the information governance of your local trust wherever you are working. I'm not sure about Nepal, those who are working, but asking those who are practicing in Nepal, do you have any local policy for information governance?
Yeah,
Hello?
yes, there is, but it's not widely in practice or in the open like in the UK.
Okay.
But there definitely is.
So one of the principle of confidentiality is you have to also understand, when you are managing this information, it has to be lawfully. We process a data in our trust. When we handle this data, there are certain processes. So there are data controllers, there are data processing people. So we need to know whose responsibility is what, and how this data is particularly processed in a safe and a transparent, and they're accountable for that. So that has to be lawfully, because any data, whether it is a healthcare organization, whether it is an organization or relevant to the government of UK, like HMRC, any organization dealing with patient data, they need to hold the data lawfully. Like, I will give you an example. You might be getting calls at times, people are asking you that you have been involved in an accident, blah, 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 and we can help you. So how do they access your data? Because of this unlawful access of data breach and data theft, this has been emphasized in the principle that you need to know the laws around it in order to protect sensitive data and share relevant information, particularly when you are in a direct care providing to a patient. You need to know what are the information that need to be disclosed, particularly for sharing any information, whether it is under a legal obligation or an exceptional circumstance where patient doesn't have capacity on his own to give you consent. You need to know. And what is explicit consent? So explicit consent and the difference between implicit consent. Can anybody tell me what's the difference? So implicit consent means an indirect sort of a consent, where the person is implied that he has agreed to the whatever the terms and condition or whatever the treatment you're giving. That can be an example like for a direct clinical care for the patient, or you are involved in a local clinical audit. Implicit consent can be taken. Other than that, explicit consent is almost invariably used where the patient has to give in written or verbal consent properly, that the patient is aware of the situation, has been informed about what the reason for the consent is being taken, and after that the patient agreed to that. Okay. Certain exception to this is you don't have to ask for any consent to the patient is when the reason for asking the consent or the situation is compromised, like a person for preventing act of terrorism involved in that, and it is required by law that you have to disclose about the information about the patient. You don't need to take a consent from the patient, right? So tell patient in as much as possible the disclosure. You can inform the patient, like I said, in certain circumstances, unless that is not practicable or undermine the purpose of the disclosure, you have to inform the patient. And always remember, whenever a consent is taken or information is being disclosed, you have to record in the patient notes, or there has to be some sort of evidence that what was the reason for the confidentiality being breached or information being provided from your side, so that you are legally protected. Okay. And access to information, you have to always make sure that your own patients or the patient where the trust you are locally, the local policy will suggest that the patient should be made aware where they need to give the consent, where they can opt out of it. That will discuss further in the local policy. So when you can disclose a personal information is when the patient consents, whether implicitly or explicitly, for the sake of their own care or for any local audit, and explicitly for any other purposes, like there is any reason that you are say involving in patient, you might be seeing for teaching and training, for research purposes, for sharing the information to some other services, for referrals to other specialties. Sometimes you think that it is an implied consent because it is a direct clinical care, but sometimes when it is not a direct clinical care, where it is relevant that your care is finished and you need to involve other services, you need to make sure, like you want to take photograph of a patient, you need to express consent from the patient, that you just can't take a picture of a wound and just send it to the plastic saying this is the wound. No, that follows the rule that you are breaching the confidentiality. Okay. So you need to be careful about the legal framework around it, where you can particularly discuss, and GMC has actually given a lot of information about it. So just go through it. Okay. The disclosure of an overall benefit where patient lacks capacity to consent, or disclosure is required by law, or disclosure is permitted, has been approved under a statutory process. These are the subtle law which can overrule the common law duty of confidentiality, or it is justified in a public interest where the consent can be, without the consent of the patient, information need to be provided. So suppose preventing an act of terrorism, which is an act of 1989, or act of terrorism of 2000. As per that, you are obligated by law to inform the relevant authorities if you feel that the public is at threat. So when disclosing information about a patient, you must try your level best to anonymize the information, if possible, to your ability that it can be relevant to the information needed. Or say suppose you have understood that the patient has given an implicit consent, but still an explicit consent is needed, but patient has not objected to it. So those are the certain situation, like research activities, or you're conducting a trial. All this needs consent in written from the patient in order to proceed for involvement of the patient information, or the patient healthcare, whatever the sensitive information you want to use in your clinical trial or the research activities. So what is it that we have to understand is any information where we have to see that the minimum necessary for the particular purpose. I'll give you an example. When you write a police report, you have to understand that the police report is expecting from you what the particular attendance of the patient was, and what was your findings, and what is your impression about it. Before to that, you need to understand under what legal pretext that the police has requested you for a report. Is it an order from the court? Is it a statutory particular act or any section implied by the police for any criminal investigation, this report is being asked for, or if this police report is being asked for by a particular express consent given by the patient himself, and police is further investigating on it. So you have to understand the necessity of the situation, what exactly the requirement of the information, and how minimum you can disclose. Where in doubt, obviously follow your own trust guidelines and take help from the relevant information governance officer or data protection officer. And there is a particular information governance group who will help you, particularly in giving particularly legal side in handling matters, in providing exceptional reports, particularly to police or to court. The trust itself helps you in that information, right? So when you're particularly satisfied that you're disclosing, always record why you are disclosing, what is the reason, and what was the main purpose for you to disclose this. If there is no evidence of it, tomorrow, say um, after a couple of years, this case has been further evolved, and a case has been raised that why was the personal information disclosed when there was some sensitive information relevant to the patient, and the patient family is not happy about it. You can't defend if you haven't documented it. So whenever you disclose, document. That is very important, okay? And always try to inform the patient when disclosure is happening, whether consent taken or not taken, unless and until, like I said, when the purpose itself is being undermined for the disclosure. In such exceptional cases, you don't need to inform. Like if somebody is carrying a gun and has attended the hospital, obviously you won't be telling the patient that I will take your consent to inform the police that you are carrying a gun to kill others, right? So you have to use that common sense there. The legal obligation on this part is when the public is at threat, or the person itself is a threat to the public, or there is certain act that you need to act quickly. You don't have to inform the relevant person or the patient, or relevant clinical condition also needed, that you need to disclose that to police to inform about this patient. You don't need to even discuss about the clinical scenario. You have to discuss about the threat that the person brings to the situation. Are we clear up till now, guys? Hello? It looks like a one way. I don't want to make it like a one way kind of a presentation. Are we clear?
Yes, sir.
Yeah. I need,
Sir.
involvement of your attendance, because just one way listening is not going to help you. Where you feel you need more information, stop me, ask me. Where you feel you need to say something when I'm asking you, involve yourself. That will really help in the session. Okay, guys?
Okay, sir.
This is a big chart just to get a summary, gist. This is a very important. It's a confidentially flow chart GMC has provided. I will not go through in detail one by one, but to get a gist out of it for people who struggle to reach to a decision when somebody approaches to them. Say a patient relative comes when the patient has died. What are the information you need to carry for? So this is a chart where you think that you go through one by one as applicable to the situation, and then come up with a decision whether it is appropriate on your part to disclose relevant information or not. Like some exceptional circumstances where there is vulnerability patient, like an adult patient, domestic abuse patient, patient with lacking capacity, pediatric patient, age related like less than 16 years, or any vulnerable child, or any associated sexual case where there is a sex offender and patient is present with that companion, and you're worried about it. So in such situation, what decision you need to come up to disclose to whom? This chart overall gives you an idea, which we will discuss in point by point. But remember, this tool is a very helpful tool to come up with a decision where you think you need to disclose any particular confidential related matter of any particular information to any relevant authority or any person approaching to you in disclosing the relevant information. Okay. Now, as I said, this is our trust policy, which was updated on 21st of July 2020. Our like rightfully, which Mr. J said, our Caldecott guardian is our medical director, but our chief information officer is Ken Anderson. But important person is Roy Underwood. You remember this name? There's an email in our NHS mail. Whenever you have any issues relevant to information governance, there is any breach of like a data breach or any confidentiality breach, and you think you need advice or you need some sort of support legally or matter where there is sensitive information involved and you are not sure what to do, this is the rightful information governance group that can give you guidance and help you in that situation to give you a specialist opinion. Can anybody tell me, other than your local information governance group, who and the Caldecott Guardian, who else can give you a legal advice when you are stuck in a difficult situation?
Your defense union.
Yes, that's the reason you are paying them every month. So Medical Defense Union, Medical Defense Shield, they have specialist advisors who can advise you on very particular exceptional situation where you are in doubt that whether you need to disclose certain information or not to the appropriate authority, or you can challenge the certain legal stance you can take where somebody is expecting you unnecessary information to disclose, which is not relevant to disclose on your part, and you think that you can challenge the decision, you take help of certain bodies. Okay, they will help you with that. Now, which we have discussed on the principles. Other than that, our local trust policy expects us, which is mandatory on our part, it's a statutory requirement that we need to be aware about the General Data Protection Regulation, the Data Protection Act, Copyright Designs Patent Act, Computer Misuse Act, and Health Records 1990. Can anybody tell me what is Copyright Designs and Patents Act? It's a statutory requirement by our own trust. Can anybody tell me?
Copyright. We know copyright, is it?
So it's the digital
For
format.
instance,
This
yeah,
act was brought where
uh-huh.
under the digital media, somebody is holding any information, he has a copyright right over it. Like I'll give an example. There are certain websites who provide specific presentation. Now you want to present on something. Say, suppose I want to present on something and I find a very interesting article and I don't see the copyright material that is there, that this person or the website or the whoever the owner of that has a copyright imprinted on it, and I take it and print it and I publish it. So I can be infringed legally on that, on this act. They can legally sue me saying this, we have the copyright of the information that we have provided. You cannot share that unless and until we give you authorized permission to publish. So like ALS has guidelines. We just can't simply print it and publish it. You have to take permission from the ALS Research Council that, okay, we need your updated asthma guidelines or your updated anaphylaxis guidelines, and we want to print it and use it for our teaching material. That comes under this act.
I think they're a little bit twisty in the copyright. Copyright is, for instance, if we are using some piece of information, which somebody own it, for a gain. Now the gain can be in the money wise, it can be in the reference, exam, that sort of stuff. So otherwise, if there's a thing on the computer, so I can read. But if I want to use it to further something, then you have to have a permission, stuff like that.
Correct. So this information is too much. Just to give a gist, it is the same principle, 8 principle, which our local trust is following on the GMC guidelines that we have earlier discussed about, along with the Caldecott principles that we are expected as a doctor or nurse or any member of our own trust, that we are expected that we will not disclose any personal information that is learned during the course of our professional duties unless patient gives their information or statute permits otherwise. This is our guarantee, the trust is saying. And this is the website I have put. The trust has very clearly put advice information for adults, for children, for vulnerable people, what is the right and in what way are they protected, how their data is stored, how their data is processed. And this is the guarantee that Doncaster Bassettler Trust is giving by openly providing on the website that this is what is expected by all the staff involved who are recruited by the trust, is expected of this standard, right? So we are assuring that the confidentiality of the patient is secured and the data is secured, and we are responsible people, and we will use the information as per the requirement, what we need in the direct clinical care or elsewhere, as much as we can protect their confidentiality so that we gain the trust of the patient and the reputation of the trust is maintained. This is a very important information our trust has put. Patient can opt out of sharing their information for some purposes like research, trials, any particular new treatment being introduced where they can opt out, or their information they don't want to share, any sensitive information they are related to, like they're following with some other specialty services and they don't information, they can opt out. But our trust has mentioned that they have to opt out from the national opt-out program, but it is not for us to opt them out, right? So we can't make them opt out, or we cannot just opt them out of the whole scenario. The patient do have the right to opt out of certain situation if they want to, and they have a right. When the data protection, there are 7 rights. The patient has a right to know how their information is shared. They have the right to access the information. They have the right to refuse if at all any consent has been given prior, that, and they have the right to know if they can opt out, and whatever the relevant information is provided when any information has been disclosed, what was the reason. They have this right under which act? Can anybody say? There are 2 acts working under this for the patient protection, for their right to know this information. Can anybody tell me? There are 26 people and none of them are actively getting involved. It seems either I'm saying something new you people don't know, or you people don't want to interact with me. Any 2 acts? So one is the Act to Freedom of Information 2000 and Human Rights Act 1998, where very much prioritized is your right to privacy. That's why confidentiality and data protection is very important in our healthcare matters. And right to freedom of information, where the patient has the right to know and access his own health records, his own process, where the data is being stored, how it is being stored under this Freedom of Information Act. Now, when you have to disclose any, like as per the same principle, if you disclose any sensitive information or confidential information, what are the exception? The same thing the local policy suggests. Now, guidance on the use and protection. This is our local policy, which follow the same GMC guidance, that we are expected that we will keep the information as confidential, and it is our legal duty to keep your records confidential, and patient information should be anonymized or encrypted wherever possible, and on the computer system is safeguarded by current data protection legislation. New computerized databases, like from outside, they have to go under a process, which is the trust senior risk, that is the clinical information governance officer, and the data protection officer is responsible for maintaining that. Any unauthorized passing on personal information by any member of staff is serious matter, warranting consideration of disciplinary action and possible risking legal action by others. We sometimes get very excited. We saw a very interesting case and we come and just bluster out to other colleagues, oh, this patient, blah, blah, blah. But just remember, this is a breach of information governance, and you can be, some disciplinary action can be taken against you if you share certain sensitive information to your colleagues who are not in direct care for the patient, not directly involved, I mean. Got my point? So certain sensitive information or certain confidentiality matter need to be very careful in handling those matter. In particularly, emergency department is a very busy department and overlooking. So these are the situation you need to be very careful when you work in emergency department. So you should ensure that unintentional breaches of confidence do not occur. Double check to avoid transmitting information to wrong person or fax machine. Do not allow sensitive conversation to be overheard. Like we think we just pull the curtain and you shout out loud, and the next 2 cubicles, all the patient and the attendants would be hearing. Just be careful when you discuss, or don't talk to patient in places where you think they're confident, like speaking to patient about the clinical information or the management in the corridor, open corridor. Try to avoid that, or taking history from a patient, or giving certain sensitive information to the patient which can be easily overheard by other people. Just be careful. Mind that is disciplinary action can be taken if the information governance team is made aware about such situation, and you can't defend that. Believe me, you can't defend that, because by law and by mandatory training you are made aware that you need to be careful about such situation. And your username, password, smart card, and PIN. We very in A&E, you see, we just open our computer. We saw about some patient information. We have just left on that, and we go and see the patient, and your computer screen is open. Even many times it happens by accidental also, it can happen. But your trust expects you that you need to be careful on that. Any breach on that, like any information disclosed through your access point, like your passport and name has been used and your smart card has been locked in and certain sensitive information has been breached or disclosed or whatever has happened, the responsibility comes to your head. Okay, so be very mindful about it and lock your screen whenever you are leaving the desk. Don't leave it for that length that it can be misused, what comes under the Computer Misuse Act. So even like patient identification doesn't mean name, addresses, or date of birth. There can be also identifying matters like your hospital numbers, NHS number, postcode, so many other things. So be careful, mindful about certain things, that patient information and relevant information that can identify a patient. Just be careful about when you are sharing or you are disclosing or you're trying to present something, teach something, share something. Just be careful about this patient identifying thing. That our local trust policy. Our local trust policy is very nicely, if you go to the website, I have put it in the reference. It really gives you a very clear idea where you need to stand, what you need to do, and what you need to avoid. Think carefully before you release information to any third party. This can be especially complicated after a patient death, when relatives sometimes need answer, which is a day-to-day thing, right? When you see there's a cardiac arrest, the relatives have arrived, friends have arrived, they want to know, they have answers to questions to ask for. Be very mindful. You be polite, but there are certain inquiries that you can direct them to, like subject access request, which is to the medical records case note release teams. They are on our main hospital sites. This is our own trust policy suggesting that you don't have to disclose all and every information then and there itself. There's a process for that. You can encourage this third party to get the relevant information through this channel. Okay, and any breach of information which happens needs to be immediately informed to the IT services help desk. One, if you need any information from Caldicott Guardian or your data protection officer, they will be more than happy to help. But there's a process to, if there is any serious breach of any confidentiality or data protection has been breached, any serious, you also need to put it in DATEX, and this has to be reported within 24 hours. What is safe haven policy? Can anybody tell me the principles of a safe haven policy?
You have put on the computer.
Yeah, but what is it? I put the principles, but what is it exactly? Why this principle work for? Like justify your purpose for confidential information, use information as when necessary, minimum information, comply with the law, and your duty to share information, care, and inform patient services. What is this? Where do we apply this? Why do we say this is our local policy? I think most of you may not be aware, this is our local policy, which is itself the Caldicott principle, or the 8 principles of Caldicott principles, where we need to use when we are sharing sensitive or patient identifying information. Either you receive it or you send it, either through email, through fax, through letters, any hard copies, like anything where this is the policy, these are the principles it works on. And we have another on this same safe haven policy. If you go through it, each and everything says, like if there is an error, suppose you're sending a confidential information, it has to be NHS email. If you want to make an official referral, what's the appropriate policy? You just can't write on a paper of thing and give it to another specialty with all the information of the patient. So there are certain policies and process. These principles work around it, that minimum information, whatever relevant to the patient care, always try to make sure that it is the data you are holding are appropriate and safe, and they're being channeled through the safe passage, like confidential matter to be disclosed in email, through NHS mail. If you're sending through fax, that has to be a guarded fax number. That's why anybody doesn't go and fax it to the specialty. If we want to give it to a TIA clinic referral, the receptionists are trained for that. They know that if how to send this confidential data to the relevant number, and if anything goes wrong, what they need to do, how to correct that. Because suppose the information by wrong has gone to another fax number, which is not responsible for the patient management. So how to act on that? So they are trained for that. So also we are trained as our mandatory training for information governance. And under this principle, that's why the local policy says this is a safe haven policy. Now, our data protection, this is a local policy, and information governance, this is used around certain laws, legal framework, which is the current data protection legislation, which is taken from the European Union. The Data Protection Act is for UK. So after the Brexit, the data protection legislation under the EU Act is no more applicable. Now it is applicable for us is the updated 2000 guidelines, which is 2021 guidelines, the General Data Protection Regulation, which is an updated Data Protection Act 2018, which almost includes much of the General Data Protection Regulation. Why it is important? It is important because this act implements the General Data Regulation as controls your personal information, which is used by organization, whether it is a UK based, whether it is EU based or government based, NHS, any business, how it safeguards your data. So like now, if anybody, say suppose you go to the website and you put your information, say you are trying to buy insurance, they will make sure that the website, the insurance has put the advertisement is data protected, that they will not misutilize your data that you're providing. That will be, your data, your information theft, what we say, can be sold to different other organization which utilizes the information, and they try to, gain some kind of profit. For that, this act has been introduced. Under this act, it is by law mandated, whoever is handling any sensitive information of any patient has to be properly processed. Very interestingly, I found this definition, which even I was not aware of. Any information relating to an identified or identifiable natural person, which is known as a data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference, such as a name or identification number, location data, or an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of the natural person. So just data doesn't mean the name and address of a person. These are so many things, relevant factors that can identify as considered as a data that needs to be processed properly, protected properly, and under the Act 2018, Data Protection Act, all these factors matters in identifying a person, and this needs to be protected as well. These are the 7 principles that the data protection works on: lawfulness, fairness, and transparency of accessing your data and processing your data. What is the purpose? Like if it is a healthcare setting, what relevant data you need? If it's a government, say HMRC, what relevant information, for what purpose? Is it for tax purpose? What is the information you need? You don't need a clinical health record of this patient. Do you need? Now, if a tax HMRC person access to you, comes to you, you are a patient doctor, and suppose they want to know the patient clinical condition. Can you provide them information?
No.
No, that would be a breach.
In certain exceptional circumstances, yes. So if the HMRC person approaches you for a relevant healthcare record of a patient that you have been directly, you are the responsible physician, and has a court order that certain tax fraud or whatever involvement, and that has relevant, that been misutilized, that the patient has been showing that the patient has been disabled for so many years, and they need to access the records to know actually the patient was claiming those benefits under the disability or not. They need to access that record, and they have the court order. You have to comply with that. But you just can't give the information if the patient hasn't given you an explicit consent for it to be, whether it's a tax person, whether it is police, whether they have to follow a certain legal framework to approach to the person holding the relevant sensitive information to disclose. So always be careful. Certain times you may think, no, I will not share the information. But if you're not sure, know the legal framework around it, or get the relevant advice. That's why I said your MDU, your information governance group, your Caldicott Guardian. I will. So why is a Caldicott Guardian appointed by a trust? Can anybody tell me?
To make sure the information governance is actually, followed properly, I think.
No, for that information group is there. That's why they create policy, they review it every year, they make sure that the mandatory training has been emphasized on all the staff involved. Caldicott Guardian is a person. Why is our current trust medical director? Because he is a more knowledgeable person. He is unbiased. He's neutral on a scenario where you are asking that the patient care is not directly being involved, intervened, or like the Caldicott Guardian is not aware of. So he is on a neutral basis, giving you an unbiased kind of advice on a situation where you think it's complex and you need that the confidentiality, whether it needs to be disclosed, breached, or somebody say legally is approaching you, says police is coming to you, asking you, this patient we are looking for has been under so-and-so situation, been missing for so many weeks, and the family members are worried. We need this person details and health records. So you are in doubt what to do. Should you inform the police about this person information? Should you not? You're not sure. So Caldicott Guardian will help you in that. So they have the principles, that are the 8 principles we usually follow, that I'll come back later. That's the same as what we follow as the safe haven policy. So national level, we have a data security and protection toolkit. It's an online form tool that all the organization, particularly our NHS Trust and all the relevant organizations who deal with data, they follow the national data guardians, the 10 data security standards. And also this organization, they have, if they have access to NHS patient data, they use this toolkit to provide assurance that they are practicing good data security. So for our trust, we have a DSP toolkit in the local policy. If you go, they usually follow these 10 standards and they keep it updated so that they make sure that the patient data are securely and fairly being stored. Now, as I earlier mentioned, Freedom of Information Act 2000 provides a public access to information by public in 2 ways. One is public authorities are obliged to publish certain information. Also, the members of the public are entitled to request information from public authorities. There are certain exceptions to this condition, like your freedom of information cannot be implied. Certain exceptions like court orders, where there is criminal investigation happening, where there is security or your national security is being compromised, or a threat or perception that national level or the public interest is being hampered. In those exceptions, the Freedom of Information Act doesn't imply. Like I said, the Caldicott, they make sure under this principle that when you approach to them, the Caldicott Guardian makes sure that you use minimal information and whatever relevant necessary. So you have a proper team. Like suppose you are being requested by a court with a court order coming to you, which a patient. Can anybody tell me a health record of a patient can maximum be stored for how long? It comes under the Health Records Act 1990.
I think the least time you need to access it.
Sorry?
I don't know if there are any particular days given,
So,
but
yeah,
I think that
it is there. That is relevant to that. So there are certain laws for that. Why I'm saying this Caldicott Guardian will help you is certain data when you're trying, if a patient has died, that the data the trust will keep is maximum to 8 years or the last treatment. This is as per England, Wales, and Northern Ireland guidelines. Scotland has different, which is 3 years from death or 6 years from the initial last treatment. But for England, the data which our trust will keep for any patient maximum is 8 years. That is for adult. For children, from 17 up till the patient becomes 25, you hold the record, or maximum 8 years from below 17 years. And if it is 17 years, you can keep up till maximum 26 years. So this is certain laws. So important take home points for you people. You need to know it is very important and part of your professional obligation. It's a confidentiality is a legal and ethical duty, but not an absolute one. There are exceptions. Remember that, go through the GMC guidance. It has 8 principles. Follow those principles. That will help you with the, the decision making tool. That will really help you when you are in doubt. You can go it step by step process. When not to disclose information, and whom to seek guidance from your Caldecott Guardian, information governance team, or data protection officer of a local. You need to be aware about your local trust policy very, very much, because information governance is a part of mandatory training for our Doncaster Bassett Law Trust. It is mandatory. You have to do it on the ESR, and you have to show that you are aware about our local information governance policy. And local knowledge about our own conduct, confidential code of conduct, you need to be aware of, because I have just given you few important points, but there are so many other things that you need to know which has been given, and I've put it in the reference that might help you. And you need to know the important point. The take home point I'll tell you is, you need to have the basic knowledge about the legal framework around confidentiality and data protection. When in doubt, seek advice rather than making an error and later on trying to recorrect it. Any doubt, there is advice, there is help. 24 hours, you can seek help. So you need to know how to get that help. As long as you are aware about this process, and you are particularly in emergency department, my top tip to you is, be very careful in sharing information, whether to patient or to patient relatives or to your colleagues. And particularly on computers, be very careful. If you're using a smart card, you should not allow others to use on your smart card anything they do. Like, say for example, any sensitive data is being breached or disclosed and it happens on your smart card, you are fully responsible for that. So just be careful of that.
Yeah.
These are my references. I think Boone is already recording onto that. That will help you. I've taken almost all which is relevant to your government of UK legislation, your ethical guidance as per GMC, your NHS code of conduct, our own local trust policies, our own, the clinical, the commissioning, whatever we need to know about our confidentiality and data protection as per our information governance. All I have taken the relevant links, and you can cross check that with the references and get more information. So thank you.
Yeah, okay. I think he has covered quite comprehensive set of this topic. Very difficult topic, as Amita was mentioning. I mean, in short, which I've got it is that the confidentiality is breached, when we use that information when it's not needed to be used. So there are few principles. So first of all, we should be prepared to justify what we've done. That's the one thing. Second is, so we need to say minimum information, and these information should be divulged on the need to know basis, and if the patient care is advanced. So again, explicit consent is, but again, little bit fine topic. For instance, people come to us for a broad thing. The people expect that we will go there. They might take history, they might do blood pressure, they might do, some blood check and the X-ray and whatever. But sooner we cross that limit, for instance, if we have to do PR examination, or if we have to do a painful procedure like arterial blood gases or appendectomy, or you end up giving more radiation. So something like that. When the situation changes, then the explicit consent finished there. So please be mindful of that. Then you have to take consent, can be verbal, can be written, depending on the extent of the procedures. So explicit consent is a little bit to understand what this principle is. So they won't consent for everything. So once that limit is crossed, then we have to take a new consent. So that's the one thing. And the second point is, we are deputy of our Caldecott, which is medical director. So we act as a deputy to him. Now, the trust have employed for our benefit the legal services, the information officer, the risk thing. So whenever you get something, patient safety, they're all people who are helping us, you know. So when you have some question and you're a bit doubtful, ring them up through switchboard, and they are bound to give you the advice. That's why they're paid for. That's why they are there in the trust. And I think the other thing is, I don't know. Do you know how long hospital keep a record, and
So
how
as per
long the
the
record is
Health
destroyed?
Records Act 1990, as per
Mhm.
England, Wales and Northern Ireland, the health records maximum can be kept is for 8 years for adult
Ah,
from death or from the last treatment. This is applicable to NHS organization also.
I think
In
there's a
case
bit of problem with the children and adult, children record and adult record.
for children, for pediatric, they will be kept up till the age of 25, or if the child is 17, up till the age of 26. Now, in case of child death, maximum 8 years.
Ah, so these are guys, these are question which examiner can ask in the paper, in the MCQ, stuff like that. Be mindful of that. Keep these things in mind, these figures. So
So
these questions can be.
certain acts I would like to all of you to know. Basically, your Human Rights Act, Act of Freedom of Information, your Act of Prevention of Terrorism 1989, Act of Terrorism Act 2020, your NHS Act 2016, which was updated in 2012 as Health and Social Care Act, further updated in 2015, and your act of your Data Protection Act 2018, which is update again your GDPR, that is General Data Protection Regulation 2021. Most importantly, you need to know certain exception where the police have a certain, when they come to the A&E, either they need to have a warrant or they need to tell you under so and so act, like Prevention of Terrorism Act is one act, there you are bound to comply with the police to provide the relevant information they need. Also, another important thing which people easily miss, the police will come and tell you so and so person is involved in accident, he had drunk alcohol, I think he's in your department, I need information of this so and so person, can you provide me? So can anybody tell me, can you provide?
No, it's not. No, you should not be providing.
Yes, you can. So police will tell you under the act is Road and Traffic Act 1988, section, I think it is 6 or 39. You are bound to provide information. You should not be a hindrance or obstruction to the
No,
information.
if he is drunk, if he's a drunk driver.
Any road traffic incident which is considered as a serious crime by the police and they're investigating, you have to cooperate with the police. That's as per the act. That's why I'm saying these legal framework, all of us need to know. These are the basic legal framework. You cannot challenge them. But at the same time, if it is not a major crime, it's a minor. So I'll give you an example. Say suppose one person has stabbed himself, self-harm into the abdomen. Do you think you need to report this person to the police? Can anybody?
No, it's a self-harm, is it? So
I think it's for all the stab wound. We have to report the police.
No, so
no,
not
this
all
is a
staff.
self-harm. This is a self-harm.
So
It's a medical
self-harm,
basis.
yeah, for self-harm, you do not, it's not mandatory for you to inform the police unless and until if the patient has intention to harm somebody else, is psychotic, and you're worried that he's a threat for somebody else's life to society. Yes, in that case, you can, other than your self-harm is not a criteria to inform to the police. So these are the things that the legal framework are working around the confidential and data protection. We think that we know, but sometimes we need to revise on it to know much more information. Finally, any questions anybody have for clarification or wanted to know, or anything you want to add before we
So
finish?
this IT record, how long trust is keep the IT record on the
8
on the
years.
computer,
8 years.
on the hard
Any
drive?
record, any health record, maximum 8 years you can keep. That's as per the Health Records Act. Anybody else? Any question?
So, Amitabh, like I've got a few questions.
Yeah.
If, for example, I've got the D number of one of the patients, which I
Yeah.
have with a small notebook, and if I keep it to myself, that is not breaching confidentiality. But I lose it, yeah, so I plan to check it. Or let's say, for example, I have actually maintained a small paper and I wrote that information in the paper and I just lost the paper. You know, in a rush, you can actually place it in some table and it has actually fallen off. You don't realize, and things like that. What are the implications and what exactly can you do about it in terms of kind of
I'll
making
give you a good
sure-
example here. What you said, the answer to that is your local policy, what your local trust expects from you, your local trust expects from you that the data should not have been, first of all, taken out of the premises. And if at all it has been taken, has it been properly stored? So like consultants, Mr. J has a laptop. Now he takes the laptop outside, which is being provided by the trust. And if that information, anything leaks out of the laptop, Mr. J is responsible for that. So he has to take care that that laptop is not fallen into any hands or not misused or not stolen. So if it is stolen, there is a process. You have to put up a datex, you have to inform through the that ISP toolkit to the information, but more or less you have to inform the information governance group that so and so data breach has happened. I'm sorry for that. What need to be done further? So they will advise you. Now your next question is certain information, like you collect all this patient information, we write on papers, and suppose it gets misplaced and you're worried that this information may fall into wrong hands or may be misutilized by somebody else. You have to put up an incident report. You have to inform the information governance group about it, that I had for so and so reason, but I feel that this has been misplaced. What do I need to do? Because if you have not taken now see, any problem happens. If you have not taken an appropriate intervention or escalated that matter and you have just sat quiet on that, then you will be considered accountable that you were involved or you're guilty in that process, what has happened. Like say, suppose you try to defend yourself that it happened accidental, there was no intention to lose that paper, but you have not taken any appropriate action on it. Like you've not reported, not taken the appropriate local trust policy, what it requires you to do. And then you will be considered responsible that you knowingly or unknowingly have done it, but still disciplinary action will be taken. If at all it really gets, I will give you an example. So one chap, he was in a very good, position. I can't disclose much. So he was changing his house. So what he did, all the things he changed, and in the rubbish, he dumped few things which was relevant to some sensitive information. And when the house owner came and they were trying to clear, they found certain sensitive information, and coincidentally, that information was related to the house owner. And he put up a legal case that was reported to GMC. So just be careful about that. The sensitive matter is sensitive matter, and you never know if it get displaced, misplaced, what can happen to what extent. So always be careful about the process that you need to involve if you are particularly working in a particular local trust, what the policy says.
No, I think
So
the
question.
the question is, for instance, if you're doing audit, so
Yeah.
audit has to be done on the premises, because
Yes.
when you do audit,
You can't sit and do audit at your home, because
so
you're not allowed to access the information unless and until, Mr. J, if you have a proper authorized trust laptop that you can access from home and you can do that audit, then that is fine. But we can't do it from our own, taking all the patient information. We can't work it on our own personal laptops. That's legally not allowed.
Yeah, because when you do audit, these educational activities are paid for the trust, so you have to be careful. And once some accident happen, do inform people, because accident can happen. They're bound to happen. It's accidents are there. So, the people take, a bit of polite view if you let them know that's what happened.
Another relevant question I have is like you maintain a logbook of your patients. Yeah, you probably keep in your shared drive in your trust.
No, there is a way for that. So Royal College, all the Royal Colleges have put off a guidelines. You go to the guideline how to enter your logbook patient details into your particular online logbook. They have given a guidance on that. So go through that. So I wanted a few
logbook information has to be anonymized, because if you're putting to GMC for everything, so they don't like anonymized.
No, Mr. J, I'll just emphasize what Suraj said. So for everybody, this is a vital information. Remember, there is a guidance from Royal Colleges particularly for maintaining patient logbook. Just go through the guidance, that will help you. And there are a few exceptions which GMC has put, how to relevant confidentiality in teaching and training, in disclosing community diseases, in it's like any criticism of website, how do you need to maintain? That's very nicely mentioned. DVLA matter, relevant certain nicely clear mention. So go through that, that really help you. Okay, guys. Boon, I think we have already reached the time.